A BC judge has issued a sharp rebuke and a hefty fine to the former mayor of a small town. Former Harrison Hot Springs Mayor John Allen was sued for defaming a local realtor. Allen's been ordered to pay damages of $160,000. A BC Supreme Court judge ruled that Allen made defamatory comments in emails, letters, and Facebook posts, falsely suggesting a local businessman, Freddy Marks, had improperly benefited from political connections and real estate deals. The judge also pointed out how Allen linked the realtor to Nazis and brown shirts, and he was directing this to a man of German descent who had relatives killed by the Nazis. Daniel Reid is a defamation and privacy lawyer with Harper Gray LLP, and he is in Vancouver. Thanks for joining us. The size of the damage award really caught my eye, but you're an expert in this area of law. How significant is that amount?
You know, this is on the higher end of defamation awards that we see here in Canada, and it's really driven by a couple of factors in this case. One of the factors that the court really emphasized is just how broad the reach of the internet is and how damaging statements on Facebook, which can spread really quickly, especially in a small community, the damage that can have on someone's reputation. So there was a real recognition by the court, not only that these allegations were serious, but that the manner in which they were published was one that warrants a significant award of damages.
Yeah, so $110,000 were the general damages here, an extra $50,000 aggravated damages. So how did the judge arrive at that, and what message is the judge sending?
Really, there's two messages here. First, the general damages award looks at things like how serious are the allegations, how broad is the audience they were spread to, and what's the impact it's had on the person. And when it comes to general damages, the court said that these were effectively gratuitous personal attacks, making serious allegations of corruption and criminal conduct, and that gave rise to a significant award of general damages. When it came to aggravated damages, the judge expressed a number of concerns about the manner in which the defendant in this case continued to behave once the case had been started. So the judge pointed to factors like the refusal to apologize or retract, ongoing publication of similar statements while the case was ongoing and after the case had been commenced, and really what the court characterized as conduct that was malicious or high-handed in nature gave rise to a further award of $50,000 for aggravated damages.
And it's not just the words that this former mayor used, making references to the plaintiff in this case being a Nazi and being a brown shirt, but the judge also looked at the history of the plaintiff who had relatives who had been killed by the Nazis, and the judge said that's what makes this defamation here particularly egregious.
Well, and that's exactly the case. One of the things the court looks at is what is the impact these words have had on the person who's being defamed. And in this particular case, those allegations of being a brown shirt and being a Nazi were found to be particularly troubling for someone who had a family history dealing with that, because they went effectively to his core as a person. So that was something the court was very clear it was condemning in making the awards that it did here.
We live in a world now, and I think particularly from what we see in the United States, where it seems like almost anybody can say what they want about anybody else without consequences. In this case, there were consequences, and I wonder, as a defamation lawyer, what do you think the lesson is here for the average person?
The take-home that I always say is, despite the fact we live close to the United States, most of our entertainment and a lot of our media comes from our southern neighbor, Canadian courts take reputation very seriously. And while we have freedom of expression, that doesn't mean freedom from consequences. So just because this type of discourse is really common in America doesn't mean that courts won't impose significant consequences, and in this case, significant financial consequences for speech that harms someone's reputation.
I would ask you a practical and maybe a slightly sensitive question to ask a lawyer, but if $160,000 is on the high end of a damage award to the plaintiff in this case, given the time it took, given the cost of legal representation, if somebody came into your office with a case like this, what would you tell them about how much it's going to cost them to get to the end of it?
One of the real challenges I think that people have with access to justice in general is the sheer cost of being able to prosecute viable claims. Defamation in particular, I think everyone in our personal life, because the bar is so low, we defame people all the time. There are very few cases where it's actually worth it in terms of time, stress, and money to retain a lawyer, commence proceedings, and spend years, and this case indeed was years in the court process, in order to get vindication of your reputation and damages. So it is something where, I always encourage my clients to think very carefully about whether or not they want to go through what can be a very difficult, time-consuming, and stressful process. And certainly, in this case here, at the end of the day, the plaintiff's reputation was vindicated. They got a judgment that not only awarded them damages, but quite importantly said these allegations were simply untrue.
And this judge's decision, which is available to everybody online, certainly sends a very strong message. Daniel Reid is a defamation and privacy lawyer here in Vancouver. Thanks for speaking with us.
It was a pleasure. Thank you, Ian.